be seated. And the matter before the court is Penobscot 23-191, the Hermon School Department versus Shawn McBreairty. Counsel appear to be present. I'm assuming ready to proceed. This matter is being streamed live on the web, both by video and by audio. We're experimenting into, for those of you who've been here many times, we're experimenting here. If counsel would identify yourselves by saying your names for the record and the party that you represent, starting with the appellant, please.
Your Honor, Marc, John Randazza, with my colleague Robert Morris, representing Shawn McBreairty.
Melissa Hewey for Appellee, Hermon School Department.
Thank you. If counsel are ready to proceed, we'd be happy to hear your arguments.
Thank you, and may it please the court. We have a profound national commitment to wide open and robust debate on public affairs. Those are the inspirational words that come out of New York Times versus Sullivan. Words that inspired me in high school to make me want to go to law school. It's where I fell in love with the law. And I hope that I'm not the only one. That profound national commitment seems that Hermon has a little bit of a problem with it. Because this case is about the government trying to silence dissent by bringing a declaratory action against a citizen where no cause of action otherwise exists. Right there, it's fatal, as we know from Sold versus Gorham, 2005, Maine 24. Now, the anti-SLAPP law in Maine protects public participation, and that public participation...
Counsel, I see that the green light is on. And so you just said where no cause of action exists, but we're in front of us right now is only the denial of the special motion to dismiss under the anti-SLAPP law. The court didn't rule to the extent there was a mention of a 12b6 in your memorandum of law below, although not in the motion itself. The court didn't rule on it. So aren't we really limited to the purposes and the elements of a motion, special motion to dismiss under the anti-SLAPP law?
You are not so limited. You do have the discretion to, if there's a matter of judicial economy, that the case will be dispensed in its entirety by ruling on that.
Well, if your basic argument is that there's no cause of action, why didn't you press the 12b6?
Well, we did. We devoted an entire...
Well, you didn't. I read the transcript of the argument. I read it's not mentioned in your motion. It's mentioned at the end of the actual memorandum of law below, but not in the motion itself, which is purported to be solely to the anti-SLAPP. And it was never really discussed in the argument below and wasn't ruled on by the court. No. The court, in fact, repeatedly said the only thing before it in the Superior Court was the anti-SLAPP motion, special motion to dismiss.
Well, Your Honor, the memorandum did devote a page and then some to it.
Is that enough?
We have raised it. It's 5% of the argument, so I don't know at what point. But I would prefer you rule on the anti-SLAPP because I am confident that you will rule in our favor on that. I think if you rule on the 12b6...
Can we find that there's an allegation of actual injury, even if in the back of my mind I'm thinking, I don't think there's really a cause of action, but that's not what the anti-SLAPP statute says.
That allegation of actual injury is doubly flawed, Your Honor. They can't claim damage as to how secondary damage by how an employee responded to criticism.
Well, they didn't just claim secondary damage. I mean, they're claiming that the school department itself is damaged. It may have to hire substitute teachers, et cetera. I mean, we can argue about whether that's really true, but...
But damaged by what? It's damaged by how this teacher claims to have responded to this criticism, but not. They do not say it was because of the 4 statements that they now rely on. They say it was because Mr. McBreairty criticized her at all. And most of the criticism here was in FOIA requests, actual official missives to the government. So they're not parsing out. You have to say that these were actually damaging by those actual statements. They haven't done that. And
so you're saying that the damage is alleged, it has to be clear that it was actually caused by Mr. McBreairty?
I believe, well, not just by Mr. McBreairty, but by the actual statements that they're complaining about. And also, your Weinstein case says that they can't claim damage in the form of something that an employee suffered. So it's not alleged properly. Even if it were, the Weinstein case says that that's not damage.
But the actual injury alleged here was that the statements, I'm just referring to the sexual predator and grooming, those statements were disturbing to the teacher and required them to make certain modifications, may lose teachers, unable to enforce their own anti-bullying rules there. It's a sequence, it's a connected sequence of events here, but those statements clearly produced that result on the other end, which was in fact damaging to the town, wasn't it?
Well, but those statements have to be void. First off, I don't say that because they haven't parsed it out. They have to do that. They can't simply say, if Mr. McBreairty said, is much of his statements, I think they even say clearly, are clearly protected speech. They're clearly protected petitioning.
Well, they say that regarding the request for records. That's all set, their request for records. But accusing a teacher in a public school of being a sexual predator and grooming kids for future sexual assaults, that falls outside the realm of petitioning. That's just simply something that would be upsetting to an employee. This is a public employer. They have a duty to their employees, and it has put them in a position of basically harm, of injury.
Justice Mead, respectfully, I think you're making the same mistake that the lower court made. You're looking at the statements. You don't like them. I don't like them. I don't endorse them. I wouldn't make them. But that's not where you begin. You begin, is the speech protected? And these are opinions. They're very clearly.
I want to challenge you on that. They're not stated as opinion, they're stated as fact. I mean, I looked at the statements themselves. I mean, it's one thing to say, in my opinion, Jones is a sexual abuser, he's a pedophile, in my opinion, clearly opinion, but to say this person is a pedophile and an abuser, that's a statement of fact.
Oh.
It's defamatory per se. I mean, I don't know how, isn't it?
It is not.
It impugns a teacher and her profession.
Your Honor, a number of insulting and really caustic and vehement statements have been found by courts to be merely hyperbolic opinion. For example, scam in the McCabe case out of the First Circuit. Nobody wants their business to be called a scam. That's hurtful.
So calling someone a sexual predator, you're saying, is not defamatory?
LaFlash versus Auburn, not controlling in this court, but I think worthy of respect, 585 F sub 3rd, dealt with that exact term. Now, one person's sexual predator, I mean, Leonardo DiCaprio is accused of being a sexual predator because he only likes to date women who are under 25 years of age. One person might call that a sexual predator, another person might call that something else. And in fact, all of the terms here, we have definitions that are at odds with one another. Both Ms. Cook, the school, and our client have differing definitions of these terms.
But let's go back to where we are. I mean, this is not whether ultimately there's a prevailing or not, but let's assume for me that the statements that he has made could be viewed as defamatory to the teacher. Just assume that. Does that provide the basis for the cause of action here?
If they could, as the lower court said, they could arguably, no. Because the anti-SLAPP law says they have to be without factual or legal basis.
Well,
if they're First Amendment protected, they're per se with a legal basis.
You're sort of putting the cart before the horse. I said assume for me that they are defamatory, which right there means.
Okay, so we assume that we've gone through a trial, we've overcome actual malice.
Assume that on their face they could be construed as defamatory.
No, you need more than could be.
Well,
Not for a motion to dismiss, you don't.
right. That's the keep where we are. I mean, we're not on a jury verdict. We're on the allegations here.
Right, but the anti-SLAPP law says they have to be devoid of. That's not simply they could be. That means there's no way they could be anything else.
What's the evidence that she's a sexual predator?
Well, again, he's saying he has laid out his rationale for that. He believes that somebody who...
Okay, so assume for me that we disagree, and we agree with the lower court that these statements could be considered defamatory, and certainly on the standard for the special motion for a dismissal, and on 12, for that matter, on a 12b6. Where does that leave us with respect to the school as opposed to the teacher?
Look, if the teacher had brought a defamation claim, we would have a different argument. But what we have is a government entity filing suit, remember, to try to enjoin my client from further speech and petitioning activity on behalf of a third party that they are then saying is being arguably defamed. I mean, the leaps just don't follow.
I'm not sure they're saying that she was defamed, but rather these statements reasonably caused her upset and interfered with her ability to conduct her duties there. This isn't a defamation case, the classic anti-SLAPP case. This is a case where the district has alleged a cause of action, saying you've done something to one of our employees which has prevented us from being able to fulfill our duties. I think that's the chain of reasoning here.
And I think as you're looking at making law for the state of Maine, think about how convenient that would be for a governor who wants to file a claim against a gubernatorial challenger. The state can the state file a claim saying, well, because these ads, these attack ads are making me feel bad and I can't come to court, we've got a cause of action and need an injunction.
So you're saying this really doesn't fly as a cause of action?
It doesn't fly one
But that's a
bit.
12b6, and then as the chief talked about earlier, is 12b6 really teed up in this case here today? We're talking about anti-SLAPP today.
I think it was teed up, but again, you have to, if you disagree with that, you still have to say that these statements were without, the statute says devoid of, not just arguably, devoid of factual or legal predicate of any kind.
And we have the affidavits here of the teacher herself, and the test isn't whether there's evidence to back it up one way or the other. For anti-SLAPP, we meet, the burden is met. With that, we take the facts in the light most favorable to the parties. So the devoid of reasonable factual support is resolved in favor of the plaintiff here, isn't it?
Well, that also has to be alleged in the complaint and in the response to the anti-SLAPP motion. They haven't done that. In fact, the response and the affidavit are at odds with each other. Ms. Cook doesn't even seem to agree with counsel as far as what parts are defamatory or what definitions you should look at. So, I mean, I think you're jumping over the fact that this kind of terrible hyperbolic language, you can call it that, scam, calling someone a scam, a traitor, a blackmailer, a terrorist, a pervert, a racist, all of these statements. Would you want to hear those about somebody? Would you want to hear those about yourself if you were a public official? Maybe putting yourself in this seat isn't a good one, but you know, these are still all matters of opinion, especially when he lays out the basis for his opinion. He believes. Thank you.
Thank you, counsel.
See you at rebuttal.
People may not be used to our red lights. Ms. Hewey.
Thank you. Good morning. I want to use my minute of protected time to underscore for the court how very important this case is for school districts and school employees around the state of Maine. It's hard to be a public school teacher for a variety of reasons, and particularly nowadays. The legislature recognized that in 2021 when it amended the education statutes to require that schools address workplace bullying, and that's what this case is about. Now, it is true that when the bullying behavior comes from an employee or a student or a parent, schools have the tools to deal with that and protect their employees. But when the bullying behavior comes from someone in the public, there isn't much a school can do. And that's particularly difficult now when we see more and more instances of public teachers being basically maligned,
Counsel,
defamed.
I see that the green light is on. You just said when the bullying comes from the public, there's not much the school can do. Isn't that the problem here? In other words, It's in front of us on the denial of a special motion to dismiss. And if we stick to, is there an allegation of actual injury or some of the other, as discussed below, aren't we just ignoring the elephant in the room, which is there even a cause of action here?
So I don't think you're ignoring, well, first off, I don't think it's an elephant in the room. And I'll talk about that in a minute. And I don't think you're ignoring it. But I do think it's not before this court.
Well, but does that make sense to affirm a denial of a special motion to dismiss if, in fact, there isn't a cause of action in the first place?
Well, in the
go
first
with me on
place,
that.
that has to be that would have to be briefed, and it hasn't been briefed because it wasn't raised. In fact, there wouldn't be a
It was
right
the last
to an
section in the
interlocutory-
memorandum below. It wasn't in the motion, as I indicated,
Yes.
but it was the last section in the memorandum.
But it wasn't briefed fully by both sides. I believe that there is a cause of action. I believe that what we're asking here for is a declaratory judgment and an injunction, because what he is doing is bullying without any merit or any basis this public school teacher. And I think that we have adequately pled actual damage by the school district. If you look at
When you talk about a pleading of actual damage, does that require proximate causation and foreseeability in the traditional sense, however, because the section 556 does refer to causing, not just pleading actual injury, but causing actual injury.
Yes, and I think that that's appropriately pled at pages 19 and 20 of the appendix, specifically paragraphs 57 and 58 of the complaint, and as amplified by the superintendent's affidavit in response to the special motion to dismiss. So what we've pled here is that the school is damaged in a number of actual ways. One is the having to hire a substitute teachers. That's monetary damage. Two is the very real risk of loss of teachers because of what's going on.
Wait, can I just interrupt you? What do you make of the argument that we just heard that this would be a terrible road to go down because any public official, a governor, a superintendent, who experiences an unhappy employee because of something they said about them can shut down the person who said the thing that made them unhappy?
So I don't think that's true. I think that people who are running for governor, public figures, are different, for one thing, than private public school teachers. These are just working class people.
I want to hear your full answer, but I'll ask you this little footnote question. Are public teachers public figures or public officials for Times versus Sullivan purposes?
They are not.
Okay, all right, you can continue with your answer.
So I think that it's a very different, the protections that the law provides for public officials, like people running for governor, and just normal people who are trying to teach our kids. And that's a really big distinction, and it's a distinction that, in my view, deserves and needs the protection
What the law provides those non-public people, and I lean to agreeing that a teacher is not a public figure, is an action for defamation. This seems to me what the district is seeking is in the nature of prior restraint under the by enjoining Mr. McBreairty from making statements. Isn't the remedy here really a defamation action for damages rather than prior restraint of what the defendant is saying are his First Amendment rights?
So I think the answer to that is no, for a couple of reasons. And we have to focus here on who the party is. The district does not have, nor does it want to pursue, a cause of action for defamation. What the district is trying to do here is meet its obligations to protect its employees. There is nothing that a school district can do other than ask for judicial intervention when people are out in social media and all over trashing our employees
But I can
with no
understand
basis.
why the district wants to protect, I understand why the district wants to protect its employees, but how is that, how is there any, I think you hit the nail on the head. We can't do it because it doesn't apply, I mean, that policy doesn't apply to him. How do you get there?
The policy applies to him.
How does it apply to him?
The anti-bullying policy? The anti-bullying policy looks at the person who is bullied, and it says you, school, need to protect your employees from being bullied.
How is he subject to how is McBreairty subject to the policy?
I'm not saying we're imposing the policy on Mr. McBreairty. I'm saying we have an obligation under the policy to protect our employees, to protect them from students, from other teachers, and from members of the public. You can't say.
But that's not what the statute says.
With all due respect, I disagree with you. I think the statute says that any conduct that essentially interferes with the students, the teachers' work it can be considered bullying.
Well, the obligation that it imposes upon the school district is what I'm saying.
It says to ensure the safety of employees and an inclusive environment for all employees and schools and students in the public school. It does not say ensure the safety from X amount of people. It's saying you, as a teacher, have the right to go to school and be safe. Be safe from other employees, be safe from students, and be
So does
safe
that mean
from...
the school district can then be held liable if somebody comes in and shoots in a school shooting?
So, no, because there's a Maine Tort Claims Act.
Okay.
Can I just ask for clarification on the statute? You're talking about Title 20, Section 1000, subsection 22?
Correct.
It says, "The school board shall adopt and implement a policy to address the negative effects of bullying of school employees by administrators, school employees, parents, students, or any other individuals associated with the public schools."
Yes.
Does that encompass just any member of the public?
It encompasses any member of the public if the member of the public is making a comment about the teacher's performance at school.
So if we
that's
disagree
not
with you on that?
But that's not associated with the school, associated with the public school, is it?
I believe that that what the statute is getting at is providing these people with a safe environment. And I think that if it wasn't for Ms. Cook's duties as a teacher, that Mr. McBreairty would have nothing to say about her. He's only doing it because of her relationship and his relationship with the school. So that's how I see the connection. I also think that that whether the statute itself specifically applies is a little bit beside the point. What we're saying here is that the school has an obligation to protect its employees, and I don't think anybody would disagree with that. And what we're saying is that because of this malicious, defamatory comments that the gentleman is making, she can't work safely, and the school has to do something. And there's nothing it can do without some assistance from the legal system. And I would just point out again, even though, as Your Honor rightly points out, we may be here arguing this again. What we're talking about here is an anti-SLAPP motion. The issues we're talking about today have not been fully briefed or
Well, understanding this is a premature question, How would you, if the conduct that is causing the harm is speech, how do you craft an injunction? And I know you've also asked for declaratory relief. And again, it may be premature, but how can you craft an injunction that doesn't run afoul of prior restraint?
So I think the language would have to be really tied to the notion of defamation, that you cannot be defaming people. And I don't think that's a prior restraint.
Can you enact an injunction in a defamation case without running afoul of prior restraint restrictions?
So I'm glad that Your Honor has acknowledged that that is premature, but I do believe that the answer to that question is yes.
Let me just ask you one final question. Obviously, some of this is focused on a statute, but are we in danger? I guess this one's a little premature too, but if we accepted the argument you're offering to us, would that set up a scenario where we were talking about teachers today, but could apply broadly across the scope of all employment, public sanitation workers or anybody who's employed in a public, by the public? The ripple effect, the mission creep could end up creating a rule of law that basically says that a governmental entity can obtain an injunction against somebody who's saying something bad about an employee, and it's causing the employee not to be able to do their job.
So I don't think that horrible hypothetical can come true, because you do have First Amendment rights, and those are established. Where this is different than the cases that you're foreseeing is that what he's saying has absolutely no basis in fact, and it is clearly defamatory. Since I'm still green, a couple of other things that I did just want to mention.
Can I jump in, please?
Oh, yeah.
While it's still green. I'm going back again to the language of the statute, and it's not just that it alleges actual injury, but causes actual injury. Doesn't that, even without a 12b6 motion, loop us into the issue of whether this is a legally cognizable cause of injury? In other words, it really almost loops you into whether it states a claim, whether it's proximate causation, foreseeability, all the things that go into that.
So I just think that, I think what Your Honor is asking is, do we have to plead actual damages? And as I said before, I think we have done that. And I continue to believe that we've stated a claim.
Okay, but there are people that, if you think about it in the, going, for example, into the emotional distress arena, where we've said, there are categories where even though somebody may be truly distressed, they simply can't recover because of the lack of duty and proximate causation, right?
Right.
It isn't part of injury that, because the statute specifically says caused injury, that kind of legally cognizable cause. In other words, the fact that there is injury doesn't necessarily mean that it's a legally cognizable or compensable injury.
So I think first that we have pled that proximate cause. What we've said is, as a result of what he said, she's not going to teach. So that's, I think that's acceptable.
As the chief, I get to say, finish what you were going to say.
Okay. So that's number one. And number two, I have no recollection of. I'm sorry.
Well, there you go. Thank you, counsel.
Thank you, Your Honors. I can refresh that recollection as to paragraphs 58 and 59 of the complaint. The only injuries alleged says such particularized injury includes, but is not limited to, the inability of the school department to protect Ms. Cook and its other employees from bullying and harassment by McBreairty as required by state law. This isn't the particularized injury required to survive an anti-SLAPP motion. Also, there was a really interesting question about whether school teachers are public figures for Sullivan analysis. I believe they are. The Connecticut Supreme Court, as we cited, does say so. But and I'd like you to find that as a First Amendment champion here. But you don't need to find that per se in this case. Because as we briefed, Ms. Cook is not just a teacher. She's a delegate to the Maine Education Association. She provides trainings for the Maine Education Association. She was a candidate for the Maine Education Association Board of Directors and frequently on political panels. That is beyond simply somebody who shows up every day and goes and teaches. But even then, teachers are the front line of the only government that a lot of us ever, as citizens, ever really encounter. Not everybody's definitely going to get pulled over by the police, but everyone's going to encounter government policy implemented by a teacher. So I do think teachers have to take criticism, whether they like it or not. Now, in this case, the only thing that's even being argued is that there was some emotional injury to her for being criticized. That's not enough. That's not enough for actual injury under the anti-SLAPP law. And Chief Justice Stanfield, I loved your question. It was one that my colleague was drilling me on all morning. But that's absolutely true, that if it is not a cognizable injury, how is the speech? Speech is always presumptively protected, unless there's a cognizable injury here, unless there's a cognizable claim, a cognizable exception to the First Amendment. What is the exception? The exception here cannot be defamation. One, it doesn't get over actual malice, but even if it did, we do have case after case that takes these vituperative statements and says that they are protected. But also, when Mr. McBreairty made these, even the one that I like the least, she says, appears to be grooming children. Well, appears to be is him saying what it looks like to him. If it appears to be improper to him, he has the right to that opinion. Obviously, it's subjective, and he's also talking, he defines grooming, he talks about that as a political or social thing. That doesn't necessarily mean where I think your mind went, and maybe even my mind went, but not everybody's mind goes there. Talks about sexual predators, says because of, and then gives the reason why. We can't limit public comment to what the government wants to approve of simply on that basis. So you have any questions? I will take my seat.
Thank you, counsel.
Thank you, all of you.
All right. Well, thank you for the opportunity to hear this interesting case. As is our usual practice, we will take this matter under advisement, issue a written decision in due course. And with that, we'll be on recess.